Good morning, everyone, and happy holidays and Merry Christmas to those who celebrate it. I'm Darren Smith of JP Morgan Workplace Solutions, and I'm your host for today's Esop Sofa, where we'll be reviewing 2024 AOTs, budgets and PISCES, and what to expect in 2025. We can only do these webinars thanks to the generosity of the members and sponsors, so a huge thank you from the panel and everyone at Esop Centre. And before we get underway, we have some housekeeping notes. Papers relevant to the discussions are available to download from the event webpage. The webinar is being recorded and the video and podcast will be available in around 48 hours. And we'll be holding a 15-minute question and answer session after the panel discussion. So please do get involved, ask questions. It's always better when it's interactive. On my panel today, I have Suzannah Crookes, Legal Director at Tapestry Compliance. I asked Suzannah her favourite Christmas song and she said, "All I Want for Christmas Is You," which I said is a little bit inappropriate as I'm married with 3 children. Only joking, Suzannah. Actually, it's Hark the Herald Angels, and her favourite Christmas movie is The Snowman. I'm also joined by David Pett, a barrister at Temple Tax Chambers. David's favourite Christmas song is Ziva Carol, and movie is Brideshead Revisited, the original BBC version that is 24 hours. Sorry, David, but that really would be a day of my life I'd never get back. Finally, I'm joined by Damian Carnell, Founder Director at Corpgro, whose favourite Christmas song is O Come, O Come Emmanuel, and movie is The Polar Express. So let's hope I can keep this webinar on track today. So a huge welcome and thank you to all the panel for supporting us today. Let's start with Suzannah and talk budgets. Was there anything in the budget that was specifically targeted at share plans, Suzannah?
Well, I think the short answer is no, in terms of things that were specifically looking at share plans. As some of our attendees will be aware, the share plans industry as a whole had really hoped that the new government's first budget would include some measures or signs of progress in relation to the call for evidence on the tax advantaged share save or SAYE and share incentive plans. The call for evidence ran in 2023 under the Sunak Conservative government, but modernisation of these all-employee plans appears to have had cross-party support, and so we'd really hope to see some progress. We're really hoping that those responses to the call for evidence will show some developments to boost the effectiveness of SAYE and SIP in a more modern format, and in turn help improve productivity, performance and competitiveness within UK businesses. However, for now, we need to continue waiting. We have had an announcement following the call for evidence on employee ownership trusts and EBTs, which David will say a bit more about shortly, but otherwise, as I say, nothing specific on share plans. But as is often the case, there were various changes announced which will have an impact on share plans nevertheless.
Yeah. One of the changes we've probably all heard in the media is the increase of the employer's national insurance contributions, which the Chancellor announced. Will this impact companies operating employee share plans?
Yes, absolutely. The secondary or employer's national insurance rate will increase from 13.8% to 15% from April next year. In addition, the threshold at which businesses will start paying NICs on earnings will be lowered from £9,100 to £5,000. So there are some big shifts there. Employer NICs is sometimes referred to as the jobs tax. So the increase in employer NICs naturally increases the cost of paying employees, and that includes the cost of offering certain equity awards or share awards. So for some companies, that is going to impact the cost of operating their share plans, and in some cases it may even restrict the equity which they are able to award where they're operating within strict budgetary constraints. Just a couple of things to note on this. First of all, the employer NIC cost on equity awards can be transferred from the employer to employees in certain circumstances. So we may see more companies considering this approach, perhaps in particular smaller businesses or those that have greater pressures on their cash flow. However, this does, of course, increase the overall tax and social security burden for plan participants, so other companies may choose not to erode the employees' benefits in this case. And then there's also the possibility for companies not currently offering tax advantage plans to consider or revisit whether this is something they wish to implement. The negative cost impact of the employer NIC changes probably increases the relative attractiveness of any of the UK's 4 main tax advantaged arrangements. So that's the Share Incentive Plan or SIP, Save As You Earn, as well as Enterprise Management Incentive, EMI, and the Company Share Option Plan or CSOP. So these arrangements generally mean that where relevant conditions are met, the benefit delivered is exempt from income tax and NIC for the individuals, and any tax arising would be capital gains tax. The NIC exemption here applies for employers as well, so the NIC saving is potentially becoming more valuable as the rate increases.
So you mentioned CGT there. This has been a hot topic in the share plans world recently. What's the latest position following the budget changes?
So I think there's always speculation around CGT rates ahead of a budget, or at least there has been for the last few years. This year, speculations around a potential increase to the CGT rate were proven correct. The Chancellor announced an immediate increase in the lower rate from 10% to 18% and the higher rate from 20 to 24%. The separate rates on residential property remained unchanged. For carried interest arrangements, there was a specific 28% CGT rate, and this is going to increase to 32% from next April. The Chancellor also announced further reforms in relation to carried interest from April the following year. On carried interest, this was probably not a surprising development. Carried interest arrangements have long been in the firing line for the Labour Party and now the Labour government. So the 4% increase does still leave the rate of CGT for carried interest comfortably below the top rates of income tax in the UK. So I think people had feared perhaps a worse outcome for carried interest. That sort of arrangement is still an attractive proposition for fund managers. It's probably worth mentioning then that the changes to CGT weren't entirely restricted just to the rates. There were wider changes announced to some reliefs, including business asset disposal relief. So the effective rate of tax where that relief is available will rise over the next 2 years to 18% from the current 10% rate. Business asset disposal relief is often available to employees when they exercise EMI options where other conditions are met. So this change will also see an increase in the effective tax rate for those individuals. But overall, the rates increases are lower than some commentators had anticipated, and so capital gains tax remains significantly lower than the top rate of income tax in the UK. That maintains the attractiveness of the tax advantaged arrangements, which I've mentioned, and other structures such as growth shares and joint share ownership plans, which fall within the CGT regime. They still carry a lower overall tax cost. I think it's interesting just to think about that rate increase in the context of the changes to CGT we've seen over the last couple of years as well, where the annual exempt amount, the annual allowance, has reduced quite significantly. It was at £12,300 just a couple of years ago. It's now at £3,000. So the impact of this is that many more employees are likely to be paying capital gains tax on the sale of shares acquired under employee share plans, and now as well at higher rates. It's probably a particular issue, and we've discussed it in the industry, particularly in the context of ShareSave or SAYE plans. So that's an all-employee plan offered to all levels of the workforce, and so typically there will be a reasonably high proportion of lower paid employees participating in a ShareSave. As mentioned, it's a tax advantaged plan, so the value delivered falls within capital gains tax rather than income tax. And in previous years, the majority of participants will have not had a CGT liability at all on sale of ShareSave shares because that will have been sheltered within the annual exempt amount. However, this is now changing, and so we're also seeing that higher rate and more of an impact for those participants.
Brilliant. And what are you seeing your clients, your companies, and also the plan participants doing about the increase in CGT burden associated with share awards?
Yeah, that's a good question. There are various ways in which capital gains tax liabilities can be mitigated in these circumstances with some careful forward planning. And so we are seeing a lot of companies looking more closely at what can be done and also at the information they can provide to share plan participants on this. For example, shares can be transferred between spouses. So you make the most use of both individuals' annual exempt amount. Sales of shares may be split between tax years. You've obviously got that annual exempt amount for each tax year. And then there are other approaches to consider, such as transferring the shares directly into an ISA, an individual savings account, which is specifically permitted for ShareSave and SIP shares. So really, this is an area where employee communications will need close attention to make sure that plan participants are first of all aware of their obligations to pay the tax in the first place. This may be something completely new for them because previously it won't have been an issue in practice. But also then that participants are aware of the possibilities for managing their tax exposure. And failure to communicate this effectively could potentially damage the effectiveness of an otherwise successful and beneficial share plan, because people's view of it will be coloured by unexpected tax obligations. So these tax changes have also brought the importance of really good financial education to the fore as well.
Brilliant. Thanks, Suzannah, for articulating the impact of a budget so perfectly there. Hopefully, you know, that's give it a quick run through for everyone on the call. Please do get your questions in. We're going to come back to Suzannah after we spoke to the other two panelists. So thank you so much for that, Suzannah. Next, we're going to go on to David, who's going to talk us through EOTs, and he's got a nice presentation for us as well. Over to you, David.
Thank you, Darren. Good morning, everybody. First slide. It's 10 years now since the government introduced an extraordinarily generous exemption from capital gains tax for individuals who choose to sell a controlling interest in a company to a special type of employees trust, an employee ownership trust. The government was constrained at the time as to the restrictions they could impose, such as, for example, they were not permitted to provide, because we were in the EU at the time, that the trustee had to be UK resident. And that, combined with the attraction of the relief, has led to a number of such structures being established in a manner which many would regard as abusive. So, for example, rather than simply sell your private company to a trade purchaser, there were tax advantages to be gained by selling it first, or controlling interest first, to an employee ownership trust, and on the basis that in due course, after a couple of years, the trust would then on-sell the company to the trade purchaser. So it's no surprise that 10 years on, there's been a raft of changes intended to tighten up the rules and ensure that the relief is targeted in a way which positively encourages genuine, ongoing employee share ownership. So what are the changes? Well, first of all, the body of the trustees must now be UK resident. There was fear on the part of the offshore trust industry that this might exclude them from acting as trustees. That's not the case, because you can still have an offshore trustee services provider sitting as trustee alongside UK resident individual trustees, for example. Secondly, next slide, there are rules now which prohibit the arrangements that were typically in place to protect the interests of the vendors. So we now have rules which are intended to ensure that the vendors cannot effectively control the trust through control of the trustee company that is typically established to act as sole trustee of the employee ownership trust. So there's a new requirement, and this applies for new trusts established after 30th October, budget day. And those who are the vendors, who are referred to as excluded participators, which also includes those who have been shareholders in the company in the last 10 years and any persons connected with them, then they must not comprise more than half the trustees, and if there is a single trustee company, they must not comprise half or more of the trustee directors of that company. Next slide. I've said who are the excluded participators. It's always necessary to look carefully to who is within this category, because there is now, next slide, an extended definition of control. So the documentation will need to be combed through, and the lawyers will need to secure that there is no circumstance in which those persons who are excluded participators have effective control of the trust. So as I've listed here, these powers would count towards control for those purposes. Next slide. There may well be circumstances in which you can accidentally fall foul of these requirements because, for example, an individual trustee or trustee director may die, and there are provisions which say that that is not going to lead to a disqualifying event and a clawback of the tax relief that was afforded, where that is simply by reason of the death of an individual trustee or trustee director, and that temporary circumstance is for no more than 6 months. So there is some leeway to avoid accidentally falling foul of these requirements. Next slide. It was remarkable in 2014 that the rules did not specifically include a requirement that the price paid to the vendors for their controlling interest in the company must not exceed the market value of the shares in question. That has now been addressed. There is what's called a new consideration requirement. The trustees must take all reasonable steps to secure that the consideration and any interest on deferred payment of consideration does not exceed the market value of the shares. Now, in the past, it's always been good practice for the trustees to secure an independent valuation report so that they have the assurance that they're not paying over the odds for the shares that are acquired into the trust. But now it seems to me that's going to be essential, because it is a requirement for the vendors to qualify for relief that the shares are not purchased for more than market value, and to evidence that you will need valuation reports both for the vendors and for the trustees. And there's also now much tighter requirements for making a claim for relief on the part of the vendors, who must inquire into and use all reasonable endeavours to determine the number of employees in the trust. That's because there's what's called a limited participation requirement, whereby if the number of employees is very small relative to the number of vendors and directors and employees connected with the vendors, then the relief would not be available in the first place. So it's in order to police that requirement that this new requirement has been made. Next slide. Perhaps the change that is of most concern to prospective vendors, sellers into an employee ownership trust, is the fact that in relation to trusts established and sales made before 30th October, they only had to wait for a further tax year next following that in which the sale is made to be able to walk away knowing that there was no further risk of a clawback of the relief that was first given. That has now been extended to 4 complete tax years next following that in which the disposal is first made. Now, if there is a disqualifying event, and there's a whole list of circumstances which might arise which would give rise to a disqualifying event, that would trigger a clawback of the relief, pretty disastrous for the vendors. Therefore, it's essential that some careful thought be given to how to protect the position of the vendors against either the trust itself or the directors of the company taking some action or omitting to take some action which could accidentally trigger a disqualifying event, which obviously obviates the relief granted to the vendors. One suggestion is that the company itself might indemnify the vendors against any loss arising from that clawback of tax relief. But it seems to me there are a number of issues that need to be thought through there. First of all, as a matter of company law, is it appropriate for a company to benefit third parties by giving the benefit of such an indemnity? Should the value of that indemnity count towards the amount of consideration received for the sale of the shares, which must be balanced against the market value of those shares, for example? And I think there's quite a lot to chew on there to ensure that the vendors are protected, and that, because typically these deals are on the basis of deferred payment of consideration, that their interests are protected over the period in which that consideration is paid in full. Next slide. Other changes. EOT-owned companies can pay tax-free bonuses to all employees and officers of the company. This was one of the carrots the government put in place to make it more attractive for companies to be sold into employee ownership trusts. There have been a number of technical issues arising from this, one of which is that it's necessary to ensure compliance with the rules of the tax-free bonuses, that all directors of the company, including non-executive directors, be included in the pool of individuals amongst whom such bonuses be paid. The bonuses are free of tax, but they're not free of national insurance, and they're paid by the company, not by the trust. And it's always important to remember that the rules governing who's entitled to a tax-free bonus differ significantly from the rules as to who may benefit from a distribution out of the trust itself. So now, going forward, in relation to qualifying bonus payments made on or after budget day, it is now possible to exclude directors. Next slide. One of the issues that has exercised minds ever since 2014 is the proper tax treatment of contributions made by the company to fund the trust, to enable it to purchase the shares in the first place. Now, very early on, Malcolm Hurlston at the Esop Centre and I had a meeting with the officer, the revenue in charge of corporation tax, who confirmed to us and followed it in writing that insofar as a contribution was made simply to cover the purchase price of the shares and stamp duty or SDRT in relation to that, then that would not count as taxable income as a distribution in the hands of the trustee. There's always been some uncertainty as to whether it's a distribution in the first place if it's not a payment in respect of shares, because the trust has only a 51% interest, for example, not a 100% interest. Anyhow, the government have sought to clarify the position, but this assumes that any contribution by the company to the trust would otherwise be treated as a distribution. And what they've said is, in effect, a claim for relief must be made by the trustees on the basis that the amount of any distribution received can, for tax purposes, be reduced insofar as it is applied in payment of consideration to acquire the shares, plus interest on deferred consideration at a reasonable market rate, and stamp duty or SDRT paid in respect of those. So they've tried to establish some certainty, but there remains uncertainty as to whether in some instances, it is a distribution in the first place. So again, that's something to be worked out. Next slide. There are some other highly technical changes which apply to the inheritance tax and capital gains tax rules as in relation to the funding of an employee's trust, not just an EOT. We don't yet have the drafting for that. It hasn't yet been published. These are all intended to remove loopholes which have been identified. Those of you who have a particularly nerdy interest in these things might be interested to read a case called Barker and Baxendale Walker, and a name that strikes contempt into the hearts and minds of advisors who've been involved in this over the years. Mr. Baxendale Walker has appeared in the context of many tax avoidance schemes. He's also, so I read, involved in the production of some saucy films, but that's another of his activities. There has been an idea abroad that effectively inheritance tax relief on sales and transfers of shares into an employee's trust is available, where the property in the trust is paid out to children, grandchildren after the death of the original participators. Whether that was technically correct was cast into doubt by the Court of Appeal in Barker and Baxendale Walker, but the government's now confirmed that it's going to legislate to make that clear. So those are the other technical changes. I'm sorry that that's a gallop through what are very highly technical provisions, but I hope that's given you enough to chew upon.
Brilliant, thank you, David. That's filled lots of gaps in my EOT knowledge, although no, I can't get Baxendale Walker out of my head. I'm sure there's lots of questions around that. It also took me back to COVID times with the next slide, so that was interesting. But thank you so much. We're getting questions in as well, which is great. So please do keep the questions coming, everyone. Next, I'm going to go on to Damian, and then we'll come back to questions at the end. Damian's going to talk to us about PISCES. Now, this is a hot topic. I see it everywhere at the moment, Damian. Can you tell us what it is, please?
Yeah, sure. Good morning, everyone. PISCES is the government-sponsored regulatory regime. It's not a marketplace in itself. It facilitates a marketplace for trading in unlisted securities. It's stamp duty and SDRT exempt, which is helpful. But the main purpose of PISCES is to facilitate the trading of shares in these unlisted companies, and therefore, for our purposes, it becomes an attractive aspect if you're thinking about operating employee share plans, either for your executives or for your employees more broadly.
Brilliant. And to what extent do you think that PISCES will mean that unlisted companies adopt new share plans?
Well, I think it's definitely a strongly positive factor. I think if you've already looked at it and decided you don't want to operate a share plan, it probably won't change your mind. But there's an awful lot of companies, unlisted companies, literally many thousands of them. And at the margin, several hundred, maybe a few thousand will choose now to go after the tax benefits of operating a real share plan rather than some kind of cash-based arrangement. It's also got a couple of other very important things. First of all, because it's a real market, the company adopting the share plan does not need, it may choose to, but it does not need to set up an EBT or an internal market through an Esop trust of some description. You've got liquidity events or liquidity windows where the employees can sell the shares. So the cost of running an EBT or ESOP for the company just goes away. And secondly, the employees will see real trades in real shares at a real open market price. You don't have to rely on some kind of share valuation formula, which some cynical employees might say, oh, is a bit fiddled by the owners or a bit fiddled by management, or it's fiddled by a combination of managers and shareholders, neither of whom are our favourite people, by the way. Here, we have a genuine share price.
Brilliant. And do you think the plans will be mainly executive plans like at Esop, or will there be broad-based all-employee plans?
I think it's quite likely that the PISCES adopters will operate the same kind of profile plans that we see in smaller listed companies. So definitely executive plans by incidence will be more common. Accessing CSOP, EMI and other tax favoured plans will be a big feature of PISCES. But we will also see broad-based plans as well. And as Suzannah was saying, the attraction of tax favoured plans, particularly in the light of NIC changes, it becomes more attractive to run tax favoured plans when tax is high. So yes, I think it's likely to take off. The enabling legislation is due in May next year. That doesn't mean we'll instantly see a huge explosion, but I can confidently predict throughout the course of 25 there'll be quite a strong growth in PISCES listed companies.
Brilliant. So looking into 2025, what companies should take note really? Should listed companies just ignore PISCES, or?
Listed companies shouldn't ignore PISCES on two grounds. First of all, they're competing for talent against the market. And that market does include unlisted companies. So this is a leg up for their competitors in a way. So first of all, just be aware that there's new kids on the block with equity in their guns, which previously maybe they didn't have. But secondly, PISCES is open to all unlisted companies. And within listed companies, there are subsidiary companies, which by definition are unlisted. And some of those companies operate phantom plans or maybe real share plans, and there's nothing to stop an unlisted subsidiary company also having its shares traded on a PISCES platform. And it may even be things like a corporate venturing unit has maybe got 70 or 90 subsidiary companies. Some of those you might want to price test about what does the market think about the growth prospects of a particular situation. So listed companies are not off the hook.
And don't know if this is a silly question, but in terms of PISCES, how many companies do we expect it to be on there? It's
really hard. I mean, this is a world first, but bear in mind that this isn't open only to UK companies. This is open to all unlisted companies anywhere in the world. The only thing that stops you being PISCES eligible is if you already have a listing, whether that's a listing in the UK or a listing elsewhere. But if you are unlisted anywhere in the world, you are PISCES eligible. So there's a lot of political clout going into economic growth from the current government and entrepreneurship and so on and so forth. And PISCES is meant to be one of the facilitating enablers of that. And therefore, I'm pretty confident. It's hard to put a number on it, but it should be several hundred over the next 2 or 3 years, I would have thought.
Brilliant. Great. So, thanks, Darren. That's given me loads of information about PISCES. I've seen it all around, but I definitely wanted to know a lot more about it. Okay, so that ends the panel discussion for now. In terms of, we're going to open it up to the audience, so please do get your questions in. We do have a few in already. So I'm going to go to Suzannah first. And obviously the call for evidence has now been ongoing. We've not seen anything. So I guess the question is, do we foresee anything happening there? Do we feel that the new government have share plans at their heart? It's definitely not top of their agenda, but are we seeing any signs?
I don't think we've got any particular tangible signs. I think the Labour Party has previously been a supporter of employee share plans, and I think we hope that that continues to be the case. I don't think we are seeing any adverse signs that share plans aren't at their heart. I think it may be a question of priorities and just some bigger fish to fry in the first few months of the new government. But I think the sense is that a certain amount of work was done in response to the call for evidence or processing those responses, around the time of the election, probably in the run up to the election, and so that there is that work that's been done that's sitting there. Whether it's absolutely ready to go or whether it's nearly ready to go, and how soon we will see something, I don't know. I don't know whether David or Damian have any views on that either.
Now, the problem is that a lot of the most effective changes come through small tinkering to existing legislation rather than new big picture ideas. For example, some of the participants may remember George Osborne's failed employee shareholder shares initiative, whereby directors and employees could trade their employment law rights for a certain value of shares with total exemption from capital gains tax going forward. That was all got rid of in 2016. But for those who acquired employee shareholder shares before that date, one of the most valuable reliefs still available is that they can sell back to the company immediately with no requirement that the shares be held for 5 years, and they get relief from the tax charge that might otherwise arise on a distribution. Now, if that form of exemption were to be extended to those who acquire shares under EMI, CSOP, SAYE, so as to enable the company to use its distributable reserves to allow employees to cash out, that would be very attractive. At the moment, there is this 5-year holding period. Another idea which has not yet received traction, which I think is a shame, is the idea that if a trust holds, say, a 5% interest in any company, including a listed company, that distributions, dividends on that holding, which are passed straight out on an all-employee basis, should be taxed in the hands of the employees as dividend income, not employment income, no national insurance, and there should be exemption from tax in the hands of the trust. That's an idea that's been around for years. It's a shame that the Treasury hasn't yet latched onto that. I'm told that there are Treasury officials beavering away on a response to the consultation on SIPs and SAYE, but it may be until the latter half of next year before we see any outcome from that.
Brilliant. Thanks, David. There's a few people who've asked what's my favourite Christmas song and Christmas movie, so I'd have to go Merry Christmas, Ed Sheeran, and The Holiday and Home Alone. I think it's because I'm just 1 month out of being a millennial. We've got different tastes on this panel. So we've also got a really good one from Tommy Shaw, Touchstone Advisory. We're already seeing a material increase in requests for independent valuations support by trustees, specifically seeking advice from an alternative advisor to those implementing the EOT. It seems this new requirement has been taken seriously by many advisors and trustees. Would you agree, David?
Yes, and so it should be. The courts put a shot across the bows in a case called South Downs Trustees some years ago, where the judge, in an appendix to the decision, made clear that he was not pleased with the fact that not all parties had been independently advised. That was a situation in which a single firm of lawyers had instructed different counsel to advise different parties to what was in effect a class action application. But the judge made quite clear that that wasn't good enough, that all parties involved should be separately advised. Now, I accept that there's not always, in the case of a small company, enough cash in the kitty to fund the fees of advisors, and that's simply not practicable. But going forward, given this requirement for effective independence of the trustee, the trust cannot be controlled by the vendors, I think we are going to see a more realistic approach to trustees being independently advised as against the company, as against the vendors.
Brilliant. Thank you very much. And we've got a couple of minutes left, so I'm just going to throw out We're going to see if you can be Mystic Meg and do your predictions for 2025, or if you prefer, what one thing you would change in the share plans world. So I'll go to Damian first. What your predictions are, what you want to change?
Well, in terms of the government, I think asking for extra tax relief is a hard ask. I mean, the government is up against it in terms of finances generally. It's also fair to say that there's a fair amount of tax relief around employee share plans, which have been built up over decades. I would like to see, however, some kind of employee share plan CGT exemption, because as Suzannah was saying, I mean, the exemption now, the annual exemption, is really very tiny, and broad-based plans very quickly will find that you've got CGT issues for your ordinary employees coming out of those plans. Most people will be horrified to know that they've got a CGT bill when they've never even thought of themselves as rich, as it were. So that's something I'd like to see. The other thing I would like to see is the government taking a bit more seriously employee share plans in some of the government-owned companies. We know we've got GB Energy, for example, which is going to be an investment vehicle. We've got another national wealth fund where it's going to be investing in companies, but we've heard zero about whether they're going to adopt employee ownership in those arrangements.
Brilliant. Thank you, Damian. And Suzannah?
I'd like to see that movement, that progress following the responses to the call for evidence on SIP and SAYE. And with that, you know, ideally some enhancement to reliefs or to the values that can be brought within the reliefs, but recognising that, you know, that there isn't an infinite pot of cash in the country at the moment. I think the main driver would actually just be simplification. As Damian said, there are quite a lot of valuable reliefs available, and I think the problem sometimes for companies and certainly for participants is navigating their way through the various conditions and steps that have to be taken to secure those reliefs, and really the sort of investment in time and cost in getting to the bottom of the tax planning, which is available and is very beneficial. So I think some movement on SIP and SAYE and some overall simplifications would be ideal.
Yeah, and sorry, we've just got another question in around PISCES, so I'll come back to you. So it's from Tom Hicks, so thank you, Tom Fiducia. Is it not likely that the costs and regulatory requirements, as well as the need for willing buyers and ability to control who future shareholders are, will put private companies off? Furthermore, there are a large number of listed companies with liquidity challenges. The challenge is often solved through the use of an EBT. How would liquidity be created? And you've got 1 minute. Sorry, Damian.
That's okay. You're quite right. Even when PISCES windows are not open, you can still operate an EBT alongside PISCES. There's nothing wrong with that. Some smaller listed companies do have liquidity challenges. I have asked the London Stock Exchange what happens if those companies choose to delist, rather perversely, delist and become PISCES traded instead. And the answer comes back, if that is a better mechanic for that particular company's circumstance, we're very happy with that. So we might find that PISCES companies graduate onto the main market, but some companies might be going the other way, dare I say. And I accept that there's mechanics in there, there's some cost in there. It's horses for courses. It doesn't mean that it won't take off for those where the circumstances are right.
Brilliant. Thank you very much, Damian. And apologies, I've had 3 more questions come through, which we won't get through, which is from Robert Pett, Sarah Anderson and Helen Hopkins. We'll drop you an email answering your questions. So all that's left for me to do now is to, again, let you know that everything we've talked about today is on the website. You can get your latest editions of Newspad. There's lots of webinars that you can attend. And a massive thank you to our sponsors, who without this it wouldn't be possible, and all our members. Also, thanks to the audience for turning up. It was a great number that turned up today. And finally, thank you so much for the panel, and sorry for abusing your song and movie choices. You've been great today, so thank you very much. Have a wonderful Christmas or holidays if you're celebrating, and we will see you all in the new year. Thank you very much for your time.
Thanks, Darren. Bye.
Thank you. Bye-bye.